I'm Jeff Bragman. I'm a member of the East Hampton Town Board, and I'm here today to talk a little bit more about the Duryea case. I know that many folks are familiar with it from many months ago, but there's some new information that sheds light on it. The owner of Duryea's is Mark Rowan. He's the CEO of Apollo Global Capital Management. He's a major political donor, and he is a $1 million donor to Donald Trump Victory Fund. In 2014, Mr. Rowan purchased Duryea's dock, and he has since tried to convert a rather casual business into an upscale destination restaurant. Two circumstances have limited his potential for expansion. One is parking, and the other is the need to put in a new alternative, innovative septic system. And one of the only locations he could do it on is a portion of the property that is zoned residential. So that's been a problem. I want to start with a meeting that happened in February 14th, 2018, about which not a lot is known. That's the date on which Mr. Van Scoyoc conducted a private meeting with Mark Rowan. He had requested the meeting, Rowan had, to resolve the zoning and planning issues at Duryea's dock and to try to break the logjam that he felt he was in obtaining site plan to convert the use into a more glamorous restaurant. Interestingly, the meeting was not disclosed to other board members until 2019, after litigation was commenced in connection with a settlement, which is the basis of the whole Duryea controversy. Van Scoyoc at the meeting was joined by town attorney Mike Sandlinski, and also attending was a newly minted councilman, David Lease. He had been on the town board for just 1 month, and one of the things that came out in his sworn deposition was that he had a nearly 2-decade-long friendship with Mark Rowan. Also present was Rowan's attorney, Judge Ed Burke Sr. Rowan brought a written agenda to the meeting, and Duryea's was the #1 topic, and he eventually stated that Van Scoyoc invited him to sue the town, and that all matters that were in controversy could be resolved in what they called a global agreement. And in his later deposition, Van Scoyoc testified that he did not discuss settlement in that first secret meeting. And significantly, at the time of that meeting, Rowan had not initiated any lawsuits. He's telling me to slow down. In the depositions, in sworn testimony, David Lease denies that he attended the entire meeting, and he claimed that he joined the meeting late and by chance. Van Scoyoc's testimony contradicted him, said he invited him specifically because it was good practice to have a second board member present. And Rowan also confirmed that Lease attended the entire meeting. Lease's testimony about the substance of the meeting was particularly evasive and contradictory. He denied discussing Duryea's, and then mentioned that he did discuss the possibility of a ferry use on the site. And he tried to explain away the contradiction, saying that was a one-off question, the only question discussed. However, Lease, immediately after the meeting, texted Rowan, and after asking for his family, the text said, "I think your global plan was laid out with thought, and more importantly, it seems there is a willingness to remedy the Duryea's delays with the town." In Rowan's subsequent deposition, he indicated that any reference to global settlement referred to the issues of concern regarding the Duryea's restaurant. Rowan then very promptly brought the first of 3 lawsuits. Just like 3 weeks later, he brought 3 lawsuits. I'm not going to discuss the substance of them. Something unusual happened when he did that, and that is that typically when you serve petitions that start Article 78 proceedings, the town serves an answer and assembles a record, a formal record called a certified return, that contains all the documents that'll be necessary to review for the court to make a decision. In his later testimony, the town attorney admitted that from the beginning, that's his phrase, he simply engaged in discussions to reach a global settlement. He never submitted any paperwork to contest any of the issues that were brought up in the first 3 lawsuits, or in any subsequent lawsuits. On skipping ahead to December 4th, 2018, near the end of the year, the town board conducted a very brief executive session to discuss the settlement of the Duryea case. It lasted only about 10 minutes. No settlement agreement was produced or discussed. The discussion was more in the nature of what the other side was asking in the case, and no decision had been reached. I was present at that executive session. I was the board member who asked for more information. About a month later, a little bit more than a month later, we had a second executive session, equally very short, about 10 minutes. Again, the town attorney did not provide a settlement agreement for review, and I raised some objections about the settlement discussions we were having. No decision was reached. There was no authorization given to the town attorney permitting him to actually settle the case. In sworn testimony, however, the town attorney claimed that he believed he was given authority to settle, but he provided no factual basis for that claim. Strangely, and somewhat out of the blue, on February 5th, 2019, the town attorney emailed the town board a court-ordered settlement. This is the first time that the town board had ever seen a written agreement. It had never reviewed it, discussed it, corrected it, or approved it. We had never taken a vote authorizing its submission to the court. So without authority from the board, he submitted it to the court and got it signed. And in addition, he signed on the signature line for the supervisor, and he signed a second time on a signature line for himself as a town attorney. Between February 5th and February 20th, the town board conducted 5 town board meetings, various meetings on various topics. There was no comment or action taken regarding the surprise settlement in the Duryea litigations. In sworn testimony, Van Scoyac subsequently stated that he didn't take any real action until a later meeting that occurred at the end of the month, February 21st. He said, in a way, it really wasn't a front burner issue. And despite his years of experience, he stated that he didn't know what to do. He didn't understand that the settlement could be challenged or undone because it was signed by a judge, and he wasn't sure of what the next steps would be. In response let me just say that the next meeting that we had that related to the Duryea case was February 21st, 2019. This is the case that put the Duryea case, this was the meeting that put the Duryea case in the public's view for the first time. And a citizen who is known as a board watcher, a regular attendee at board meetings, stood up and he stated some fairly careful criticism of the agreement and mentioned the failure to have taken a vote. And at that time, prompted by those questions, I spoke up and said that the agreement was grossly one-sided in favor of Mr. Rowan, and I suggested that its terms thwarted environmental review, that it did not protect Montauk, and that we had not voted on it. Van Scoyac and the town attorney's reaction was notable and strange. The town attorney immediately took the podium and declaimed that I was the only councilman who didn't work hard on the board, and I was the only councilman who didn't work hard on the settlement. He then claimed that I was attacking the town attorney's office and disparaging the employees of the town attorney's office for not handling the case or doing a good job. What he failed to mention, and what I didn't know at the time, and what the public didn't know, is he was the only attorney handling the case. No one else in the town attorney's office handled the case because they all had conflicts and they couldn't participate. While this attack was going on, the Van Scoyac joined in the attack, and he repeated the claim, "We know who works hard on the town board. 4 out of 5 of us work hard." And I would suggest that that statement is probably about the worst thing you could say about a public servant, but also clearly designed to discredit me. And in subsequent depositions in 2020, Van Scoyac and all the town board members admitted under oath that they did not work hard on the settlement and that it was only discussed in the 2 brief executive sessions that I just described for you. And in fact, Van Scoyac specifically admitted under oath that his attack on me was false and that it was motivated by his anger and that he knew the moment he said it that he should not have said it, and he called it a misstatement. That is a polite word. I call it a lie. When asked directly if he had worked hard on the settlement, he stated, "I was angry and I misstated that." In other words, he had not worked hard on the settlement. When asked if other board members worked hard on the settlement, he states, "No, not any harder than I described earlier about our executive sessions and what was discussed." He further stated, "In hindsight, that was a misstatement, and I knew as soon as I said it, I probably shouldn't have said it." And when he was asked if his statement that 4 out of 5 members worked hard on the settlement was political, he said it was a statement he made without thinking about it. He said it was an attempt to exert damage control and an attempt to mitigate the public view of things. He justified his attack by describing it as being done for public relations. Curiously, at the end of that meeting, when it became controversial, David Lease texted Mr. Rowan immediately after the meeting, and he called it, forgive me for being a little bit vulgar here, a grandstanding shit show. And he said, he noted that Bragman was just one vote. Later, when he was deposed, Mr. Lease admitted under oath at his deposition that at the time of the February 21st board meeting, when he was assuring Mark Rowan that I was only one vote who would vote against the settlement, he had not even read the settlement. He admitted under oath that he hadn't even read the settlement. Following the events of the February 21st meeting, things got a little more political when Democratic committee member Andy Harris emailed Kathy Burke-Gonzalez, another board member, to suggest that he knew of an opportunity to, quote, throw Bragman under the bus. The next period of time immediately preceded a meeting in Montauk. It was March 10th and March 11th. As an attorney who practiced in land use and did litigation, I understood that hiring independent counsel was now a necessity. So I met with my fellow board members, and we reached an agreement that we would replace the town attorney with independent counsel. And Mr. Semlensky promptly agreed to recuse himself from the case, and independent counsel was appointed. A couple of days later, we had a Montauk work session at which Duryea was discussed. In that work session, oddly, Mr. Van Scoyac was speaking with a citizen activist who opposed the Duryea lawsuits and applications, and he insisted that it would be legal to install a commercial septic system on residential property. Challenged by that citizen to tell her where in the town code it permitted that, Mr. Van Scoyac could not cite the basis for his claim and said he'd get back to her later with that information. Notably, Rowan's plan to convert a casual eatery into an upscale restaurant required the installation of a septic system on adjacent residential property. What happened eventually is council brought a motion to stop the settlement. And on April 10th, in an unprecedented hearing, the court ordered the entire town board into Supreme Court for most of the day so that he could take testimony on the application to stop the settlement. It occupied an almost entire workday, and the chief building inspector was there. At the end of that day, he issued a temporary restraining order stopping the enforcement of the settlement. A temporary restraining order, one of the bases for granting that kind of relief is that you have to show a likelihood of success on the merits. Oddly, the next day, Mr. Van Scoyac issued a press release, and in that press release, he indicated that he was pleased with the outcome because it would enable the town to settle the case. And that is a very unusual response, to having just fought a very tough battle in obtaining the temporary restraining order. I want to talk about the hearing testimony that happened on April 10th because it illuminates what was going on in the case. In its testimony for the first time, Mr. Van Scoyac admitted that he had met with Rowan in private in a meeting that remained secret. But he said only one issue was discussed, and that he said it would have to be resolved in court. He also acknowledged that the settlement as written would have overruled a 1997 Zoning Board of Appeals decision in which he had participated as a member. However, subsequently, when he was deposed in October, Van Scoyoc denied that he had discussed settlement in the February 2018 meeting. And that claim that they didn't discuss settlement contradicts the lease text that was sent immediately after the meeting referring to a global resolution, where he said, "I think your global plan was laid out with thought," and that there's a willingness to remedy the Duryea delays. Also, Mike Sendlensky, the town attorney, testified in the April 10th hearing, and he said that from the beginning he was looking for a global settlement. In other words, no effort was ever made to contest the lawsuits that were filed. And the question is, on whose authority did he make that decision? And later, in Rowan's sworn testimony in his deposition, he stated explicitly that global settlement referred to the claims relating to Duryea's dock. I've described the press release that Van Scoyoc issued immediately after the hearing, which immediately signaled that we would be open to settling the case. And I wrote him an email immediately to the town board and said that it was highly unusual and ill-advised to suggest that the town's intention was to reach a settlement in a case in which we had never seen the written agreement, negotiated it, or voted on it. In a sworn affidavit was submitted by Rowan after that hearing happened in early May. And for the first time, Rowan overtly stated that at the meeting that had been a secret, Van Scoyoc, Lease, Sendlensky, and his attorney, he said, "We addressed each material issue covered in the final settlement agreement between the parties." He explicitly stated that they were discussing settlement. And at that meeting, he said that Mr. Van Scoyoc stated that he wanted to globally resolve the issues, but he needed to do it in the context of judicial action because town politics and public pressure would make it impossible to settle otherwise. And he stated at that time that he asked him to file suit to provide the town with political cover. Rowan later modified that statement, and he said when he was asked, were you asked to sue the town? He said, not in those words. And again, the David Lease text referring to the global approach and referring to Duryea's delays corroborates Rowan's account of what happened at that meeting that was kept secret, as does Sendlensky's conduct in not fighting the lawsuits. Thereafter, in May, September, October, November, and December, Mark Rowan launched 4 more lawsuits for a total of 9 lawsuits. Something odd happened in May of 2020 that involved Rowan that does shed some further light on the Duryea case. Van Scoyoc telephoned me shortly before we were going to have a work session, and he proposed to do Montauk COVID testing in the Montauk Playhouse. There had been some urging to get a COVID testing site done in Montauk. So he went to great lengths to describe the footprint of the Montauk Playhouse and ended the telephone call by saying, of course, Mark Rowan is going to be paying for the COVID testing. I immediately objected to bringing Mark Rowan into a town-sponsored project. I saw it as an effort to burnish Rowan's reputation, and I thought that it immediately raised a serious conflict of interest. By this time, the town had spent about $500,000 fighting the Rowan lawsuits. And Van Scoyoc was insisting that Southampton Hospital wouldn't do the testing unless Rowan paid for it. And he finally authorized me, the town board as a whole, authorized me, when I objected, to go talk to Southampton Hospital and see if that wasn't true. And that's what I did. So I contacted the chief administrative officer of the Stony Brook Southampton Hospital on June 1st, 2020. And I stated to him that, we felt that it was our obligation as a local government to fund COVID testing and would prefer to do it, and asked if he'd have any objection to doing that instead of the plan with Mark Rowan. And he immediately said it was perfectly fine and that they would be happy to do that. And at that point, I emailed the entire town board and indicated that it was agreeable to the hospital to do it. Now, notably, the hospital was never going to pay for COVID testing. They were just going to run it. So the funding was a key issue here. But what happened after I sent them the email that said that Rowan was unnecessary is that Van Scoyoc interceded with the hospital. And afterwards, he stated publicly in a board meeting for the first time that Southampton Stony Brook would run the program. And he acknowledged that Rowan was a donor to the hospital. And after that time, on June 9th, 2020, Dan's papers reported that Van Scoyoc had set up a new arrangement with Stony Brook Southampton Hospital, and the article ended noting that Mark Rowan told The Independent that he saw it as essential to increase testing in Montauk if businesses like his restaurants were to reopen. And Mr. Rowan is known for his philanthropic efforts, including efforts with Southampton Hospital. So the point is, after I raised a potential conflict and a complaint, an ethical complaint about involving Mr. Rowan, Van Scoyoc continued and pressed and got him back into the arrangement. And later, on June 25th, the Star reported that a private donor's contribution to Stony Brook's public testing was helping to underwrite the project. And I wanted to say also that I wanted to make it clear that when I've referred to the meeting that started this whole tale off, the meeting in February of 2018, that no one on the town board knew about that meeting other than the participants. And on July 28, 2020, Councilman Burke Gonzalez in her sworn deposition testified that she didn't know about the meeting. And to my knowledge, no one on the town board knew about the meeting. So I want to wrap up with some what I call lingering questions here. And the first one is a fairly obvious question. Why was the first meeting with Mr. Rowan kept secret from the town board? And I would add that New York State town law requires the supervisor to keep board members advised of all developments that involve the town board. The second question is, why did Van Scoyoc bring David Lease in to meet with Rowan in the first place? Lease was the least experienced member of the town board. I'm a land use attorney with 35 years experience, but Lease had been friends with Rowan for more than 2 decades. And the third question is, if Mr. Van Scoyoc had truly been blindsided by the settlement, which was by all accounts a bad deal for the town, why was his immediate response to join with the town attorney responsible for negotiating the deal in an attempt to discredit me? And, I want to say, make no mistake, when a town board member or a town attorney or a supervisor attacks another town board member and says, he's not working, it's the worst kind of criticism that he could make. And it is a clear attempt to discredit me. The other question is, why was Mike Sendlensky looking to settle the cases from the beginning, meaning March 2018, after Rowan first initiated the lawsuits? It calls into doubt Van Scoyoc's denial that they didn't discuss settlement in the 2018 meeting. And of course, I've mentioned David Lease's text, which mirrors the language in which they describe the potential settlement. And why would Van Scoyoc state at a March work session, after we had won the decision, that it was permissible to install a commercial septic on a residential property? Why would Van Scoyoc announce, after winning an injunction, that took an entire day for the entire town board, that it would allow the parties to continue to negotiate a settlement after such a significant victory? And finally, why would Van Scoyoc go out of his way to make sure that Rowan was involved in COVID testings despite the lawsuits and the attendant legal costs after I protested about his involvement? And I want to just conclude and say this. This is not about my feelings being hurt. This is about what appears to be a breach of a breach of the commitment that elected officials make to the electorate. And the other thing, I have to say is that that breach cost the town $500,000 in a time of COVID. And finally, although I'm in a campaign, this is not an issue because I'm in a campaign. I'm in this campaign because it's an issue. This is a very serious issue, and this is the first chance that we've had to fill in some of the gaps that we didn't know back in February of 2019 when I first objected to the settlement. And I hope that it helps illuminate for the public what really happened in the Duryea case. If anybody has any questions, we can talk. I know that's a lot of material. It's longer than I wanted it to be, but if not, I'll just conclude. If there are no questions.
Well, can you just say a little bit about why you're bringing this up now? This meeting happened 3.5 years ago. I think we all covered it when those depositions came out. So what's new here that maybe we didn't know before? Or?
What's new really is all of the links that I was talking about came out in subsequent depositions which the press knows nothing about. When we were talking about the case back in February of 2019, nobody knew that Sandlensky was the only lawyer that worked on the case. Nobody knew there was a secret meeting that occurred a full year before that no one was advised about. And in fact, this information didn't come out until the depositions came out, were printed, corrected, and they extended into October, November. So all the links here that explain, it was, to me, when I first heard about the case, it was inexplicable why there would be no paperwork on the case. Why were there no answers filed? Why was there no record assembled? But when you learn that there was a meeting in February at which they discussed, filing lawsuits that wouldn't be contested, it explained it. So a lot of this information came out much later. You haven't seen it, and it's all public record, and it's from sworn depositions by the parties.
And you kind of stopped short of accusing the supervisor of wrongdoing by trying to get Mark Rowan involved. You just kind of raising the questions, but can you maybe make that link a little clearer about why you think that he would want Mark Rowan to be involved with
the COVID testing?
Yes, yeah.
I think it was an attempt to. I want to say that Mr. Rowan is a philanthropist, and he's a contributor to Southampton Hospital. But I think it was an attempt to burnish his reputation. I think it would have made it easier for Van Scoyoc to just settle the case and say, well, come on, he's a good guy. He got us Montauk testing. And my objection, I thought it raised a clear conflict. We were actively engaged in 9 lawsuits with him. We had spent $500,000 fighting those lawsuits. But more importantly, the town had the funds to do the COVID testing on its own. It wasn't that expensive. It would have cost $16,000 a month. And we could have set it up, on using our own money. And I think that would have been the appropriate thing to do.
And how did that ultimately get settled? What ultimately happened?
Well, what ultimately happened, I believe, is that Southampton Hospital, took the credit for paying for the Montauk COVID testing, but the clear implication is that it was based on Mark Rowan's contributions. So he was, I believe, it's my opinion that he was part of the transaction. And it's an odd thing to do when he's a plaintiff in 9 lawsuits that have cost us $500,000.
Question?
I don't know, the question was, is the number still $500,000? I don't know the exact number. The question is, answer the questions that hang on. The question is, why don't you answer your own questions? I don't want to go through each of the questions again. I've taken a lot of time. But I would say that the sworn testimony that we now have, combined with what we now know from depositions about how the cases were handled, the fact that we now know the town attorney acted alone, I think that Mark Rowan's description of the purpose of the meeting is in many ways corroborated by the sworn testimony. And I think that's the answer to all of the questions that I raised. That being said, I have no more, and I want to conclude this conference. Thank you.